From Lazada, Philippines, we have Mr. Justine Campana and Attorney Glyza Arago. From Amazon Philippines, we have physically present, Ms. Christine Ann Mercado Tamayo. Present online, we have Mr. Sarthak Luthra, Ms. Tatiana Falcao, and Mr. Leaf D. Ridwan. From Shopee Philippines, we have Attorney Jem Han Segovia and Mr. Philip Fulon. From KPMG, we have Ms. Maria Carmela M. Peralta. From Deloitte Philippines, we have Attorney Tristan Lopez. That will be all, Your Honor.
Thank you, ComSec. Today we'll be hearing 3 items on the agenda. Number 1 is Senate Bill number 250, and the title of the Senate bill is an act imposing value-added tax on digital transactions in the Philippines, amending for the purpose sections 105, 108, 109, 113, 114, and 236, and adding a new section 105A of the National Internal Revenue Code of 1997 as amended, authored by Senator Pia Cayetano. The other one is PS Resolution number 20, or PS Resolution number 20, entitled Resolution Urging the Senate Committee on Ways and Means and the appropriate Senate committees to conduct an inquiry in aid of legislation into the possibility of imposing and collecting taxes from multinational online streaming services and the digital economy in general, authored by Senator Bong Revilla. And it was transmitted to us, November 15 from the House of 2022. It was transmitted to us, House Bill number 41200. And the title of this House Bill 41200, an act imposing value-added tax on digital transactions in the Philippines, amending for the purpose sections 105, 108, 109, 110, 113, 114, 115, 236, and 288, and adding a new section 105 of the National Internal Revenue Code of 1997 as amended. So we have 3 items on the agenda today, basically all imposing VAT on digital transactions in the country. And just a brief opening statement, in the quest to assist national government to raise additional revenues for different priority measures. We all know that we are still reeling from the pandemic as well as high inflation in the past few years. The committee is in unison with the national government in the quest of increasing revenue take or increasing revenues to help support priority programs of government. But at the same time, we all acknowledge that the digital economy is moving so fast, faster than the laws that we have already in place. And one of the adverse consequences of not keeping up with the digital economy is the uneven playing field between offline or physical transactions as well as online transactions. So an offshoot of the bills that will be tackled today is to even the playing field between physical transactions as well as online transactions. Of course, legislating policy to in effect regulate the digital economy is very tricky, as the digital economy is evolving as fast as anyone can imagine, as well as the digital economy is very dynamic, as we all know. So legislating this type of bill becomes very, very tricky. So we requested the assistance and also the opinion of our experts who are with us today. I know that a lot of you are exposed to different regimes, different jurisdictions. A lot of you have been working in with various multinational companies, and your experiences will truly help this committee craft a legislation or a piece of legislation to adapt to the present times, especially in the realm of the digital economy. So with that, we'll go on to the discussions of the bill, and we have a few resource persons from the government agencies. We'll start off with them, and then later on we'll go into we request the resource persons from the private sector to give us their insights and also their experiences in this type of legislation. Um, so with that, we'll start off with the DOF, who's with us today, and we'll start off with some basic concepts, of course, how this will improve revenue coffers, and then, of course, we'll go into what we can still improve in the bill. No? So with that, we'll call on Yusek Napao for the DOF's presentation, and then later on we can also hear from the BIR, and then we'll go on with the government sector first before we go to the private sector. Right?
Good afternoon, Mr. Chair. Afternoon, everyone. Allow me to read the DOF's statement of support for Senate Bill 250 and House Bill 4122. The Department of Finance fully supports these measures. And presently, the government's thrust towards taxation of the digital economy is focused on the collection of VAT on digital services, which include digital advertising, subscription-based services, and other services using information communication technology-enabled infrastructure, among others. I'd like to emphasize that this is to be distinguished from the digital services tax, which is a form of income taxes or direct taxes imposed by other jurisdictions. We would also like to emphasize that this bill does not impose new taxes, but merely strengthens and streamlines the Bureau of Internal Revenue's authority to collect VAT on digital transactions by providing measures on how resident and as well as non-resident DSPs can comply with the VAT requirements imposed by the tax code. Mr. Chair, I also have here the ED Marlene Kalubag, as well as the team from the BIR led by Sir Larry Barcelo and Director Parinduque to further provide details of our presentation. May I request that ED Kalubag will be recognized, Mr. Chair?
Yes, ED Marlene, you're recognized.
Good afternoon, Senator Win Gatchalian. The National Tax Research Center fully supports the passage of the VAT on digital transactions, explicitly including digital services, particularly by the non-resident service providers into the VAT coverage. This will clarify the liability of non-resident DSPs to collect the VAT and remit the same on the transactions that pass through their platforms. And it is also informed that in the ASEAN, at least 7 countries are already implementing this tax on non-resident DSPs, and also as well as other countries. And lastly, this will give the government additional revenue. And since we computed, at least in the first year, at 50% compliance, we'll be having 12 billion to 16 billion in 2028. That's all, Your Honors. Thank you.
Parang maiksi yata ang DOF and NTRC state their position, but how about the BIR? Do you have any position?
Good afternoon, Your Honor. For the BIR, we also subscribe to the position of DOF. We support the passage of this bill. This is timely, and it will strengthen and protect the tax base at collection to the BIR. And as already said by the chairperson, it will provide a level playing field between non-resident service provider, digital service provider, and resident service provider, brick and mortar businesses, and those who have no physical presence in the Philippines, Your Honor. Thank you.
you. I during the I requested the before this meeting we had a briefing on this proposed measure, and the PowerPoint presentation that you made is quite informative. And it's good to put that on record, no? So that everyone can see, aside from us and the internal team. But it's good to make that presentation because you have a lot of information that can clear up some of the concepts here and establish the intention of the bill more thoroughly. So I would like to, if you have the PowerPoint presentation, Yusek, and it's not so long also, no? That PowerPoint, I think it's only a few pages. We can do that presentation so that everyone will be on the same plane, and later on the discussions will be more attuned to or more narrowed to the concepts of the bill. No? So is that possible? Are you ready to make that presentation?
Mr. Chair, perhaps I can just read through this presentation, and I also invite the other members of my team to make a comment whenever they want to provide more information thereon. But may I request that this slide be put up on screen? Ito na ba yun?
It's good to discuss this presentation because a lot of the basic concepts should be included in the transcripts of this discussion. So aside from, of course, the expression of support, which is highly appreciated, but I think what's important is the reason and the logic for those support. So, and I have a copy of that presentation that you made, and it's quite informative. So it's good to um, lay that out in the transcript of records. So we'll suspend the hearing for a while. hearing, and let's start with this presentation.
Thank you, Mr. Chair. Next slide, please. Mr. Chair, would like to begin with the rationale of why the DOF is supporting and pushing for the imposition of VAT on non-resident digital service providers. As a way of background, we know that under the tax code, any sale of goods and services in the Philippines or supply of services rendered in the Philippines, whether electronically or manually, these are generally subject to the VAT. While offshore transactions, we generally regard this as VAT exempt. But in recent years, we noticed that there's the growth in the digital economy, and in fact, various jurisdictions and our we know that the OECD countries has been pushing for the taxation of the digital income in various jurisdictions. So we think that there's a need to revisit our tax code in order to capture the income related to the online services that are performed through servers outside of the Philippines, but these services are really availed of by our citizens. So while it is true that these are characterized as this may be characterized as before as services rendered outside the Philippines, recent trends show that many jurisdictions have considered that these services can qualify as services rendered in the jurisdiction of the country where the citizens are availing the services, such that this validates our theory that these services, digital services, can be subjected to VAT based on the principle that the supply of services in the Philippines is subject to our VAT laws. So, given that as a background, we, next slide, please. We do understand that this is a gray area, but we also recognize that there are a lot of jurisdictions now, including many ASEAN countries, our ASEAN neighbors, that have already implemented and captured these services as subject to either VAT or the GST. This slide just simply would further explain why the DOF and the BIR have been advocating to really capture the this income, online income, to be subject to VAT, as we note that not taxing this non-resident digital service provider, the digital service providers, and as we already know that we also have local digital service providers that we have been imposing VAT. So we are saying that this could lead to inequitable tax treatment between these two taxpayers. In effect, we also would like to create a level or an even playing field for these service providers. And when we impose VAT on the transactions of these for both domestic and the non-resident DSP providers, we are in effect creating an even playing field on these businesses. And we also note that if we continue to not impose the VAT on these DSPs, non-resident service providers, we are in effect eroding the tax base. So we think that this is high time to capture and not lose out on significant potential revenues that could increase our or shore up this VAT on these transactions. In the next slide, Mr. Chair, this supports the earlier statement that this will show the different countries that have already adopted
Yusek.
the VAT on digital services.
Yeah, hold on, Yusek. We'll just um, fix the technical error. Ha? Walang internet. Before we continue with the presentation, I just want to capture on record certain clarificatory items so that will increase the enrich the transcripts. Earlier on, the Executive Director Marlene said that this will enable to clarify some of the items in the tax code. No? Can you explain, ED, what are the things that needs clarification in the tax code insofar as digital transaction is concerned?
Yes, Your Honor, because under Section 105, persons liable, we don't have explicit wording about digital or electronic transactions. So if these words will be included in Section 105 of the VAT provision, then it will not confuse anymore the coverage of the VAT. Because even if right now digital transactions are supposed to be VAT, but in terms of non-resident digital service providers, it's not clear if they are covered. That's why we need to capture this group of supposed to be taxpayers.
But the transaction or the consumption of those services happened here in the Philippines.
But Your Honor, the non-resident are not covered yet. But other countries, they're already imposing this VAT on non-resident.
What in the law prevents from non-residents to escape the VAT imposition? Because in my interpretation of 105, render services, that means if you render service, my at least my interpretation or my understanding of this is the services were consumed here in the Philippines. The customers are also located here in the Philippines.
If they're registered here, Your Honor,
Hmm.
then VAT is paid, supposed to be paid in the Philippines. But if they're not registered as VAT taxpayers, then this escapes our VAT debt.
So the first step is to register them.
Yes, Your Honor. And when we, as gathered from other countries, it's mandatory. We have a document in other countries that registration is mandatory. We can submit, Your Honor.
So the first step is to register. What if they don't register? So they're still not captured by the system.
That's for, I think, for the BIR to answer, Your Honor.
But again, we'll talk about that later on. We'll finish the presentation.
May I request for the next slide? So, Mr. Chair, going back to this presentation, these are the examples of countries that have, in fact, updated their tax frameworks to capture the revenue from digital transactions and services. We are only putting here the VAT rate because we know for a fact that the issue on capturing the income taxation on these digital transactions is still not clear. In fact, there are ongoing efforts now with the OECD. And in fact, even the UN has also launched studies. We call it the two-pillar solution, which will address the income tax aspect on these digital transactions. But for our purpose, we really intend to capture the VAT, just the VAT part, because as it is shown in the slide, this is an acceptable scheme. Not only with the various jurisdictions, but I think even the industry players have agreed to comply with this imposition of VAT. So in the table, Mr. Chair, we can see that there's Philippines, Cambodia, Indonesia, Japan, Laos, Malaysia, Singapore, South Korea, Taiwan, Thailand. These are ASEAN, Asian countries that have adopted the VAT on digital transactions. There are various rates, and since VAT and GST, these are more or less similar impositions, Singapore is imposing GST on digital transactions. But there are various thresholds. For the Philippines, that's our caudal threshold of 3 million pesos. The other countries have either higher threshold or lower than our 3 million, Mr. Chair. So in the next slide, this will just highlight what we are proposing in this bill. In the left side, these are the features that this aim to clarify the imposition of VAT on electronic or online sales services. This also defines who are liable for digital service. Who are the digital service providers that are liable? This requires non-resident digital service providers to register for VAT purposes if their gross or receipts for the past year have exceeded 3 million. And this will require non-resident digital service providers to collect, we're talking now here of the platforms, to collect and remit the VAT on transactions that pass through the said platform. In the shaded box, those are again some of the features that the provision for educational services or digital transactions relating to educational services, as well as the sale of online subscription-based services. This will be still exempted from VAT. There's also the feature of simplification on invoicing and as well as the registration requirements for VAT registered non-resident digital service providers. The bill also has a feature of not allowing or there's a preclusion for non-resident digital service providers from claiming creditable input tax. And the last point here is that these non-resident DSPs, they are required to designate a representative, a Philippine representative, or to designate an agent to assist them in complying with the provisions of the tax code. Mr. Chair, the next slide would show the estimated revenues that may be collected if this bill will be signed in or passed into law. We have columns for 2024 up to 2028, and assuming that there's only 70% compliance among those DSPs, we note that in 2024 alone, there will be a 17.64 billion collection, additional collection on the part of the government. And then moving to 2025, it is growing to 18.96 until 2028, wherein there may be a total of an amount of 23.28 billion, Mr. Chair, on a 70% compliance. On a conservative note, we have, if there's only 50% compliance, it is also shown in the table, Mr. Chair, that for instance, in 2024, 50% compliance would yield 12.60 billion in VAT revenues for 2024 alone. I think if we will use a 100% compliance, this will, for the 5-year period, I recall that this will amount to around 145 billion, Mr. Chair. And for a 50% compliance, that would, the 5-year period would yield around 77 billion pesos, Mr. Chair. I think that is our last slide, Mr. Chair. I would like to thank the chair for allowing us to do this presentation.
Thank you, Yusek. So I just want to get the basics recorded in the transcripts. I was asking ED earlier, what in the law does this bill intend to clarify? So meaning there's certain provisions in the law, obviously, that are not clear or are gaps in terms of allowing the BIR to enforce VAT on this type of transactions, digital transactions. So, so that we will capture it on record, which exactly in the provisions of law, of the law, that is being considered as gaps in terms of enforcement. So I'm sure that either the DOF or NTRC or the BIR.
Yeah, Mr. Chair, just a sort of rejoinder on the statement of ED Kalubag on that what provisions in the code that clarifies the DOF, the BIR, part of the government, we always have that position that these types of services are rendered in the Philippines, and such that we do have the right to tax them. But if you're on the other side, you also have that position that citing case laws and perhaps rulings that there were instances in the past that rulings on the location of servers. They're saying that based on cytosol taxation, these because the servers are outside the country, the services are performed there. But this is perhaps the trend that different jurisdictions have adopted the taxation of digital services, and the trend that they have been able to capture. And since the principle among different jurisdictions, they are the same. The VAT attaches to the services rendered. So this validates our earlier position that in fact the services that are being enjoyed here or rendered here by the non-residents are in fact services that are subject to VAT, Mr. Chair.
Yusek, I agree with you. I completely agree with you. But I want to capture from, of course, the BIR or the DOF or the NTRC, what exactly in the law is missing, or what exactly in the law is unclarified. Just to rephrase the question, do we actually need a law to enable the BIR to impose VAT on digital transactions, especially coming from non-resident digital service providers? So that's I mean, the same question, but phrased differently. So I want to pinpoint in the law what is missing. What are the gaps in the law that we want to plug in order for the BIR to impose VAT on this type of transactions? I want to pinpoint exactly in the law because people will ask, we have the law. How come we're not implementing the law? How come BIR is not implementing the law? I know that there are rulings from the Supreme Court. Let's discuss that so we capture that on record. What prevents you from imposing VAT on this type of transaction? And again, no, this is in the context of even playing field because you can impose it to, I understand in the disclosure earlier that you can impose to local we have local digital service providers and they're paying VAT, no? They're imposing VAT. So what is the uh, the legal problem that prevented BIR from doing the same for non-resident DSPs? So any BIR, you might Assistant Commissioner, you might want to answer that.
Your Honor, in addition to the statement of Yusek Dakila, the digital service is classified as service, performance of service, and both under income and under VAT, no, services are the situs of services are where the services are performed. For income, that's in section 42, I think, of the tax code. That services, the situs of the services are where the services are performed. And in the VAT also, services are VATable because these services are performed in the Philippines. You mentioned earlier that dito naman ginagamit yan. So in effect, parang services rendered or used in the Philippines. But under the enumeration of Section 108, wala po siya yung digital services, no, na naka-enumerate. Meron po doon ng mga services that that are taxable in the Philippines because this is being used by the resident of the Philippines. For instance, royalties, no, the list or use of privilege to use royalty, patent, formula, process, if the user is in the Philippines, that royalty will be subject to VAT. The supply of scientific, industrial, commercial equipment or information, and even services rendered in relation thereto, if the user is in the Philippines, they are subject to VAT because the user of the Philippines. But that's only the enumeration. That the situs is the jurisdiction of consumption. The online services, there are no mention about that in Section 108, and that provides uncertainty or vagueness on the whether or not they will be subject to VAT. Also, in Section 114, no, it only enumerates the withholding system, no, the VAT withholding to be done by resident on services performed by non-resident, but it is limited only to the lease or use of property rights. No, payment of lease or use of property rights to non-resident owner. So hindi po clear talaga whether these digital services, especially if they have no physical presence in the Philippines, will be really subject to VAT. I think that's the vagueness comes in, Your Honor.
For let's say for diba we have I heard earlier there are local DSPs, no? There are existing local DSPs. They're paying VAT.
Yes, Your Honor.
And you know, the DSPs when you say local DSPs, they're registered
Yes,
here.
they are here in the Philippines.
So regardless where their equipment is, as long as
Yes.
they're registered here. Kasi like for example,
Yes.
let's take Amazon for example. You can lease servers abroad. Like for example, you're a e-commerce company here in the Philippines, but you can lease the servers can be abroad. No? So it's important they're registered with the BIR, no? So that they can impose VAT. Okay, and if the company is not registered with the BIR, can the BIR go after them if they are offering services here in the Philippines? What is the recourse of BIR to that effect?
If that is digital services, Your Honor,
Digital
because
services,
they
digital
have
services.
no physical presence in the Philippines.
Yeah, because online is typically there's no, you can be anywhere. You can be.
The standard, Your Honor, is the tax authority is imposing penalties and sanctions. And in the present bill, I think, and in the version of Congress version, there's a provision there amending the Section 115 on the suspension of business, no, in case of non-registration or non-compliance with Section 236 on the registration requirement, to suspend the operation of this digital service provider. And in relation also to that, there's the implementing rules, whether this be physically or suspended or to be done electronically or through other applications. This will be discussed or deliberated by the implementing agencies. Like that, I think they included the DICT as one of the implementing agencies of this regulation. So that's, I think, the way to enforce compliance, Your Honor, is still penalties, fines, and sanctions.
I'll go back to the suspension, no? Because again, we're talking about the digital realm. No? There's no physical store to shut down or to close. What we obviously all of this is done digitally or electronically. No, so I'll go to that. No, whether the country has the capability to do so, and so that we can again capture that on record. I saw in the presentation, Yusek Napao, that we're not actually imposing new taxes, no? But rather capturing uncaptured taxes. So can you elaborate on that so that we can enrich the record, Yusek?
Thank you, Mr. Chair. it's based on the premises, Chair, that we somehow has the position that these services are performed here in the Philippines, and that we have the right to capture or to impose taxes on these services. Um, uh, so that's a premise of the statement that in fact these are not new impositions. It's just providing clarity, and we are perhaps strengthening our by enacting this provision. We are strengthening our position that these services are can be subjected to VAT.
What you're saying is the VAT, the 12% VAT right now is being imposed. However, with this type of services as well as this type of entities, the law is not capable of imposing it on them. Is that tama po ba yung aking description?
Perhaps the term would be there will be resistance. We cannot effectively implement the same, Mr. Chair.
So
as there
have the
would be-
BIR tried to impose VAT on this type of transactions? I know the BIR is quite creative in many ways, no? So have you tried to impose this type of the VAT on this type of transactions? And what happened, no, when you tried that, no? What
Your Honor, on the digital services that are being rendered by the registered taxpayers in the BIR or within our taxing jurisdiction. The problem is, yeah, we can tax this, but we cannot really enforce because they are not in the Philippines. They are not registered, so we cannot even audit them. They are not here. We cannot look at their books. So that's really the constraint, legal constraint, Your Honor.
So if that is the constraint, where did you try to, of course, in this type of situation, there must be a recourse, no? And the recourse typically is closure or suspension of business. But in this case, yun na nga, no? It's in the internet. No, you cannot go there and padlock the internet, no? So have you tried suspending the website or suspending the outlet or the website outlet?
We had discussion with the NPC, National Privacy, NTC and DICT on that, Your Honor, because as you know, they're also monitoring the web, no, on any unlawful or illegal posting there. And I think the ICT, insofar as, for instance, posting pornography, though, so they discussed to us about this program or application that they can shut down operations, but not really on matter of taxation, on matter of taxation. So the discussion is still ongoing, Your Honor.
Why not?
And,
Why come I know one time the NTC shut down a few if I'm not mistaken, websites that are considered subversive. I remember that, no? So in other words, they have that capability, no? But
Yes,
I'm not sure. Of course, that's subversive, no? So that's detrimental to national security. But for taxation purposes, obviously they have that capability. But for taxation purposes, have you engaged NTC or DICT to help you enforce the collection of VAT?
Your Honor, in the BIRs, on our side, while we are mandated to suspend, but this only refers to physical business establishment. So there's really no law yet that that empowers us to suspend online, no, business conducted online. Especially, they don't have any physical presence in the Philippines. So I think this law will now, if it is passed, will empower the agencies concerned. If it is BIR, then in coordination with other agencies, because really medyo mahirap talaga online so kasi so we really need the coordination or ano with NTC or DICT.
In other words, given that they are capable, technically capable, but there's no legal basis to do so. Okay, so we end parang dead end tayo to that effect. Yeah, I just want to get that on record. I heard earlier also from ED that there are 7 countries in ASEAN. No? So medyo late na tayo, considering that that's majority of the countries in ASEAN. What countries are those, ED? And can you give us also some idea on how they impose VAT on digital transactions? No? Just on ASEAN lang. Let's not talk about OECD, and just on ASEAN, because uh, seems to me that we're quite late already, no? Considering that the Philippines is considered an emerging economy. But looking at the list, naunahan pa tayo ng Laos, no? And Vietnam, no? And Cambodia, no? For that matter. So, in fact, I was talking to some people from Netflix. They were surprised that we don't have this type of regime in our country, no? Because they view the Philippines as an emerging economy, a fast emerging economy. So, so these are on the screen. These are the ASEAN countries. But in your study, what are the best practices, Executive Director? Just core, just common best practices from these jurisdictions, so that we can learn from them. Because my view is, since we're late na tayo, ang beauty with being late is we can copy, no? And we can learn from their mistakes or learn from what they're doing good or what they're doing well. No, that's the beauty of being late. So just give us an idea. What are the best practices? What things that we should emulate from them? What we should also avoid from these countries?
Okay, thank you, Your Honor. I have here, say in Cambodia, they issued sub-decree number 65 that they set out the regulation to implement VAT on electronic supplies of digital goods and services for domestic consumption made by non-residents that do not have a permanent establishment. So at the same time, other e-commerce activities registered with the Cambodian tax authorities are subject to VAT on the supply of goods and services. Indonesia imposed VAT on digital goods and services from abroad to domestic consumers through also the issuance of what they say, what they call peraturan. Sometimes, Your Honor, we have a difficulty in the language, in the translation. But starting April 1, 2022, the Indonesian law on harmonization of tax regulation will raise the VAT rate from 10 to 11 and will raise it further to 12% in 2025. And that's including already the VAT on digital goods and services. For Laos, they impose supplies of goods and services by electronic means. And they require non-resident vendors of digital services to businesses and customers in the country to register and be subject to the 7% VAT on February 24, 2022. So in Malaysia, a 6% service tax is imposed on the following: software application and video games, music, ebook and film, advertisement and online platforms, search engines and social networks, database and hosting, internet-based telecommunications, online trainings, and other digital services provided by a foreign service provider to a consumer in Malaysia. So certain services such as digital services related to online newspapers, online journals and periodicals, and online distance learning services On the other hand naman, they're saying they're exempt from the 6% service tax. That's just like in our bill, we are also exempting e-books and other publications from this proposal. So in Singapore, 8% goods and services tax beginning January 1, 2023 is imposed on digital services, including downloadable digital content, subscription-based media, software programs, electronic data management, and support services performed via electronic means to arrange or facilitate a transaction digital in nature. It also imposes, well, these are other things, zero-rated GST and the supply of international transport, like sales of air tickets, online courses for overseas individuals, and other international services using digital platforms. Myanmar is planning to regulate and manage e-commerce businesses for tax purposes, to encourage competition between registered and unregistered businesses. In Thailand, non-resident providers of electronic or digital services, such as digital products, search engines, electronic data management, to consumers must register with the Thailand Revenue Department and be subject to 7% VAT. Vietnam imposes 10% VAT on domestic transactions, the sale of e-commerce websites providing e-commerce services, such as commerce trading floor, online auction website, online promotion website, other types of websites regulated by the Ministry of Industry and Trade. Applications installed on network electronic devices and identified e-commerce activities conducted by mobile telecommunications networks. So Vietnam, last September 29, 2021, it issued Circular 80/2021 detailing the implementation of the tax administration law. The said circular set out the mechanism for the tax administration for foreign and overseas suppliers that do not have permanent establishment in Vietnam, but engage in e-commerce and/or digital-based transactions and other related activities, effective January 1, 2022. And of course, Brunei Darussalam does not impose any VAT or VAT-like structure.
Based on your analysis, Edie, what are the best practices? What are the things that we can learn from these ASEAN countries? If you can name, let's say, 2 or 3 best practices based on your analysis, and I can see that you.
They must be registered.
So there must be. So that's a very
For
important
what purposes?
for feature.
And there must be, because they have here a permanent establishment, or they authorize somebody to, for compliance, to register and pay the VAT for compliance. And of course, in our case, I'd like to go back to what I said earlier about Section 105, because we don't really have a provision that digital services are subject to VAT. That is why we are inserting Section 105A, Your Honor, in that bill. That should cover digital service transactions. That is what is lacking in our tax code.
So in your analysis, the registration is very important.
It should be mandatory, but yeah, I think in other countries they have somebody from like say from our country. Netflix for one, I think Netflix has Netflix Philippines.
And you in your analysis also local presence
It's not It's not necessary, Your Honor, because there must be like digital VAT or digital administration.
okay, but you
Because
mentioned
they might hide in cloud, or they might avoid having physical presence because of so many how to comply. There might be difficulty in complying with the law.
so your so one of the observations that you have made is from other jurisdictions they have to have physical presence in one way or the other. Tama po ba? Is that
Yes, Your Honor.
okay?
There are jurisdictions here that require.
Okay. Um, Anything else that you have observed from these countries?
That's all, Your Honor.
Mr. Chair, if I may ask.
Yeah, go ahead, Yusek.
Mr. Chair, the wording in this bill, which is registration for VAT purposes only, this is somehow a deliberate provision just to avoid the issue on these non-residents to have a PE here. Based on under our laws, if the company will have a PE in the Philippines, then other form of taxes will come in, and just to since our purpose is to capture just the VAT, the wording in the bill is that um, the registration will be just for VAT purposes, and that it should be interpreted that this will not lead to the establishment of a PE, Mr. Chair. And just another feature, I can mention Thailand. Thailand imposes the VAT on digital transactions on only on B2C. Um, uh, or business to I mean to those non VAT consumers. So they require the non-resident digital service providers to pass on the VAT. But with respect to B2B transactions, they retain the withholding tax, withholding VAT scheme, which is what we already have put in place, Mr. Chair, with respect to purchases by our VAT registered businesses or companies. So I think that's one feature that we can look into. And the House version does not have that scheme. The House version is it generally says that subject to the VAT, whether or not it's B2B or B2C. But I think, Mr. Chair, we can perhaps look into that model whereby for B2C, we can impose the VAT on the non-residents, while for B2B, we can retain the withholding VAT scheme. I think if the BIR can further explain the B2B and B2C concepts.
Go ahead, Assistant Commissioner.
On the, as I earlier mentioned, Your Honor, under Section 114, that provision allows for VAT withholding, no, on the on the leased payment on the lease or use of property rights to resident owner. And if we will follow that to this bill, to digital services, then we can also adapt that VAT withholding, meaning the resident consumer buyer of the Philippines, VAT registered here because they are engaged in business and they are supposed to be VAT registered, they be the one withholding and remitting the VAT to BIR instead of the non-resident supplier or platform provider. That will be administratively convenient for the BIR, and this setup is already in the BIR. We are observing at present that setup. There's a form for that, for the VAT withholding on payment to non-resident owner, lessor, or owner of property rights, which used by the resident consumer, no, in the Philippines. So there is an existing procedure on that. So we can just adapt that. But on the business to consumer, that's the setup being mentioned by Asek Daki. That withholding will be applied to non-resident digital service provider or online platform provider, because mostly these consumers are not VAT registered individuals. So the withholding will not apply to them.
So none of the proposals actually made a distinction between B2C and B2B. No? So I see wisdom in making that distinction, no, for administration purposes. So in other words, if we make that distinction, it will be easier for BIR to administer for the B2B. That is being done right now.
Yes, Your Honor. That is
Okay.
being done right now on the payment on the list and use of property rights to resident owner. That's
And-
why we will now expressly state that will apply also to digital online service provider services, then VAT withholding will apply.
Okay, so that I think during the period of the TWG, we can amend the proposals. Okay, how about for goods, USEC? This only deals with digital services in
Mr.
section.
Chair, we don't intend to impose VAT under this bill on the goods because they generally be subject to the VAT on importation when they pass through customs. So it's not included, Mr. Chair. Just a note, but there is that provision in the CMTA whereby it says that importation amounting to less than 10,000 pesos, this will be exempt from duties and taxes, Mr. Chair. So, including VAT.
So in other words, you should buy from a online platform items amounting to more than 10,000 pesos. You're subjected to VAT at the customs when the goods arrive here. Tama ba?
Yes.
So it's
yes,
already
Mr.
in other words, it's already captured. No, it's already captured, except for the de minimis provision in the CMTA, where 10,000 the threshold is 10,000.
Yes, Mr. Chair.
Okay, alright. Kaya pala pag bumibili ako sa Shopee, walang VAT eh. Kasi maliliit lang naman yung binibili ko. All right, so I have some more questions for the DOF, but we have a lot of resource persons, so we'll do the rounds. We'll start off with BOC. Any sa mga customs? Ayan. Any comments from the BOC?
Good afternoon, Mr. Chair. The Bureau of Customs would like to adhere to the earlier manifestation of the Department of Finance. Rest assured of the no objection of the Bureau of Customs regarding the passage of this bill, and we ensure our commitment to observe the provisions of this bill once passed into law. Thank you, Mr. Chair.
Thank you. Thank you for that. Just for the record, when you collect the VAT, when customs collect the VAT, is that remitted to the treasury, or does it go to the BIR for recording purposes? What's the internal mechanism?
I believe it, well, I
Alam
think
mo ba?
it's not remitted yet,
Huh?
Your Honor. It's not remitted yet to the Treasury
Yeah,
directly.
yeah, maybe you can
Thank you.
answer that.
Mr. Chair, we confirm that the collection of VAT along with the duties and taxes go to the BTR account. Opo.
Okay. All right, thank you.
Your Honor.
Thank you to the BSP. Where's the BSP? Nandito ba? Yeah. Any comments?
Yes, Mr. Chair, the BSP would like to express its support to the intention of this proposed legislative measure, given the recognition of the goal to adopt an efficient, fair, modern, and progressive tax system that would enable the government to have a viable source for public sector funding requirements. We understand that this approach seeks to have an equitable distribution of the burden of taxation between the brick and mortar business establishments and those that have already adapted to the current times through the use of digital platforms. And in relation to what our colleagues from the DOF and the BIR also mentioned, we'd like to suggest the study study of the different taxation approach in our ASEAN peers, which we have also noted in our research have adopted a tax on digital services. And we noted there that specifically in the case of Cambodia, they adopted this VAT reverse charge system for B2B type of transactions, which may help us in collection of VAT, because collection from non-resident may be a potential implementation concern for the BIR. So we have all other suggestions in the position paper that we have previously submitted as well, Mr. Chair. And we just want to clarify also that given the scope of the bill, we understand that only non-resident digital service providers are being considered to be covered under the bill. So, and as the body would also be aware, the BSP has been espousing the promotion of the conversion of payments into digital form. So we wanted to clarify that the fees collected, for example, by our payment service providers, which are all our resident corporations and also licensed by the Bangko Sentral ng Pilipinas, they are already being subject to the appropriate tax. So we just wanted to ensure clarification that they will not be covered by the subject bill. Thank you, Mr. Chair.
Thank you. Thank you for that. We'll call on DICT. Dito pala DICT. Yeah, ma'am.
Good afternoon, Mr. Chair. The DACT fully support the passage of this bill, and we welcome for the provision of any technical assistance that we can provide during the TWG meetings.
When we enact this bill, and then we specify that we can, let me backtrack a bit. We have that capability to block websites. Is that possible in our government? Is that capability within our government?
Actually, sir, as mentioned a while ago, we need the legal basis to do that. But if the DACT can do that, yes, sir, through the National Telecommunications Commission, through the ISP or the Internet Service Providers po.
And what will it take for the DICT or NTC, which is an attached agency, no, of
Yes.
DICT, to block websites that are in violation of our tax laws?
We need a case or at least a case order to do that, sir.
Obviously, a legal basis
Yes po.
is also needed.
Yes.
Okay, so once we have established the legal basis, of course, the internal due diligence and due process will happen between the two agencies. But the legal basis is important.
Yes, sir.
Right now, is there a legal basis to your knowledge? For example, if BIR goes to you and say, this website is not paying the right taxes, can you go and turn off that website? Is that, I'm sure you can, that's possible, but can you do it legally?
For this, sir, we still have to review the existing regulations for related, especially for the tax related transactions, Your Honor.
But to your knowledge, can you do it legally? Is that legally possible for the ICT to turn it off?
Actually, sir, the DACT would mandate or would instruct, especially the internet service providers, since they are the one hosting, if they are the one hosting the platforms or the services.
If the platform is outside, no, we're talking about this. These are outside mega platforms. These are huge.
Actually, sir, it's also one of the major considerations during the
Because we might put that in the law, but if we're not capable of doing it, then if we can only do it, alam ko before, these are small websites hosted
Yes.
here. No, but these are giant websites.
Yes, we have to do further
Because we might put it in the law, but if you're not capable, then what's the use?
we have to do further study, Your Honor. Actually, this is in reality, especially for one, if it's not hosted within the Philippines or the jurisdiction, marami kasi silang ways, especially for the IP, they can easily change that, so we cannot use that as the basis. Even the MAC address of the devices, pwede din po siyang mapalitan. So we have on the part of the DACT, we have to do deeper and further study regarding this, Your Honor.
For now, you're not sure if we can do it?
Your Honor, for those
These are big websites, hosted outside, no? And they're
for
not-
those not within the jurisdiction of the Philippines,
But in principle, ba, can the DICT block websites being shown here in the Philippines? Is that possible? I know in China they can do that, but they can block Facebook, they can block yung mga social media sites. They can filter out unwanted topics. But can we do that? Can the Philippines do that? Do we have that technical capability?
we'll check with the Cybersecurity Bureau. Pero, Your Honor, I think if it's not really in the jurisdiction of the Philippines, especially nga po kasi when we block websites, we have, you can do that by filtering, by using the word filtering, by using the IP address, which can be changed. The best way really to block or to take down websites is through the service providers, kung saan po talaga sila naka-host. Yun po yung pinaka-best way.
This is outside. We're talking
Yes.
about we're talking about mega websites outside. These are not the small ones that we're
If
seeing
this
here.
would
No?
pertain to the national security, this one we can work out with our Cybersecurity Bureau, Your Honor.
Yes, give us
That's fine.
feedback on that because that's a very important component of this bill.
Yes.
That's the recourse that where we want BIR to have, no, as a power. Right now in the law, it's closure, no, physical closure, no. But we cannot close websites physically. No? So
Note of this, Your Honor.
give us a study on that, no? But that's a very important component of this bill. So give us a very detailed answer to that effect.
Noted, Your Honor.
All right. So we'll go on to our private sector resource persons, and we're very honored and privileged that you gave us your time to discuss this very important measure. So we'll go with the TMAP. Attorney Suzette is here with us. Attorney Suzette, any comments on the bill or any suggestions?
Yeah, Mr. Chair, good afternoon. Well, PMAP supports any effort and proposal of the government to raise revenues. However, we have some clarifications just to be put on record as to the effect of this proposed bill. Particularly, Mr. Chair, on the coverage of on the supply of electronic and online services that can be delivered through an information technology infrastructure, such as the internet. We believe that this is a broad provision. So just to put on record, we want clarification, maybe from the BIR or from the chair himself, if this should cover those services rendered online by, say, a foreign consultant or any person rendering services offshore, but delivered through, let's say, through the internet, such as Zoom, like consultancy services that's rendered or being performed through Zoom or email. But we believe that the intention of this law is for the non-resident foreign service provider to be rendered through a platform, like a fixed platform. We're not very techy, but we want to understand and clarify what is really covered by this seeming catch-all provision. Just to put on record here, Mr. Chair.
Go ahead, attorney, and then we'll just
Okay.
request DOF or BIR to answer in one go.
Yes. And also for clarification, Mr. Chair, with respect to the amendment of the taxation, the imposition of VAT on services per se, that it should be limited to digital services. What we are concerned is when the current rules on the performance of services on physical services, which supposedly should be imposed on services performed within the Philippines. And that should not be included by the amendment proposed for digital services only. In short, Mr. Chair, the actual physical services would still be subject to VAT for the performance of services in the Philippines. On the other hand, the VAT imposition on digital services, I understand from the bill, will be imposed based on consumption of the digital service in the Philippines. So just to put on record, Mr. Chair, that's one of our concerns. And in addition, we are also would like to clarify on how the penalty on non-registration of non-resident digital service providers will be imposed or will be enforced, considering that a major penalty for non-registration or even non-remittance of VAT by the non-resident foreign service providers will be closure, temporary or permanent closure of the business. And okay. Isa natin. Do you have anything to add? Wala na. What about? Oh, yeah. 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 And also, just additional note, for further discussion before on the, okay, well, compared to the vatability of local or Philippine registered digital service provider, when they are rendering services here and then the consumption is made here in the Philippines, obviously it's subject to VAT. But if they are rendering services here, but the consumption or the consumers are located abroad, the tax code is still clear that whether it's digital or physically rendered, that it's subject to 0% VAT. So it's still comparable that they could be subject to 0% VAT for services rendered here, but consumed outside by a non-resident tax or corporation or entity. So in the same manner that for non-resident foreign service provider, if they render it abroad, then they could be subject to VAT under their under the laws of the country. And then when they render abroad, like in the Philippines, they could be subject to 0% VAT. So it's still comparable. And lastly, Mr. Chair, we are while we are also supportive of the government's efforts to raise revenues, definitely who are the taxpayers or the ones who will be most affected will be the consumers, and because obviously the government will collect taxes that will be passed on to the consumers. So from B to C. So from B to B, so it might not be very the government might not generate much revenues for that, since the business entities or taxpayers have input VAT to or have like maybe, yeah, input VAT to offset any of the output VAT. Okay. Based on our previous discussion, Mr. Chair, we have started also a survey of the countries in ASEAN and even some from Europe, and but we will submit once we complete the review. We've already have a partial tabulation or summary, and for Asian countries, I think we have the definition under SBN 250 generally has the same definition in other countries. So digital services, advertisements, online and online platforms. And we focus mainly on who will collect, what they how they enforced. Basically, well, most of the ASEAN countries imposes the obligation to remit the VAT on the non-resident supplier. There are just some cases where they have like in Indonesia, the PMSE VAT collector that supposedly registered in Indonesia, but most of them imposes or gives the obligation on the part of the non-resident taxpayer. Meron ka? That's all for
Thank you.
today.
Thank you, Attorney Suzette. May I get the um, reply from DOF on services rendered online and then delivered through email? So I think the scenario here is, if I'm not mistaken, Attorney Suzette, is uh, consultancy services. No? For example, foreign consultancy services. I think I remember Attorney Malu also mentioned this. Foreign consultancy services. It was engaged here, but the services were done outside, no? And then delivered through, obviously, through the internet, no? Whether it's via email, Zoom, or other platforms. No? In section E, page 4, line 8, seems to me that is covered. No? I want to get the reply of USEC if that is the intention.
What section?
Mr. Chair, based on my discussion with Sir Larry, we both agree that the the income from that form of services, Mr. Chair, consultancy services, maybe could be covered under this bill, Mr. Chair. If we look at on page 9, the exempt transactions, we only included educational services, which and it says including online courses and webinars that are rendered by private educational institutions duly accredited by the DepEd, the CHED, and the TESDA, as well as those rendered by government educational institutions. It appearing that when Mr. Chair does not fall under this exemption, then that may be covered by the bill subject to the VAT.
That so it's covered, no? So for example, consultancy services, I know that we have a lot of that already, no? Because the world is becoming boundaryless. You can engage, let's say, services of consultants outside, but obviously you're charged here, and then all the work is done outside, no? So the intention is to capture that as well. No? Tama ba, Yusek?
Hindi eh. Okay, Mr. Chair, can I ask for further clarification?
Yeah,
So
go ahead.
what if, for say, a foreign lawyer who usually well render services or physically or through phone, through email. So there's a request for an advice, and then the output from that lawyer is given through email, or a video conference rendered through Zoom. So is that covered by the bill? And if so, we believe that this is not the intent of the any taxing jurisdiction in capturing the digital the revenues from digital service, which should be which arose from the from the expansion of like the Netflix streaming services, and it shouldn't be it shouldn't cover those who are rendering professional services, or otherwise it could have rendered physically. Before it was via phone, and then with the advent of technology, then they can send it through email, through Zoom. Isn't it like stretching the coverage a bit?
Right now, in that scenario, are we capturing that? For example, foreign consultants uh, getting clients from the Philippines. Now, these are traditional consultants. No, we're not talking about streaming service. We're talking about legal services, architectural services. These are traditional services. But the reports and the communications or the conclusions are all delivered electronically. No, so in effect, it's not a digital service. No, because it's the work is actually traditional work, but just delivered through electronic means. So that type of scenario, are we capturing that? Are we imposing VAT, or how are we capturing that type of scenario now at this regime? At present regime.
Present regime, Your Honor, it will depend on who will be the client of this consultant. If it is a VAT registered entity, then he has to withhold or any payment to foreign consultant. The problem is if it is not a VAT registered entity, if it is individual, we cannot require the foreign consultant because he is outside our taxing jurisdiction.
So the VAT registered entity is mandated to withhold for that service, for that
Yes, Your Honor.
service.
If, yeah, that's to capture the transaction, the fee on that transaction.
Ginagawa niya na ngayon. It's being done. I mean, based on your
Yes,
experience,
yes,
it's
Your
being
Honor.
done. Okay. Okay. So in other words, there's no need for if it's being done, do we still need to put that in the law?
Yes, Your Honor. That's really the clarification intended by this law. Because as to the enumeration under the tax code, there are only enumerated services uh, s- performed by non-resident owner or person that are subject of VAT withholding. As I said, one of them, or among them, one is yung payments to royalty payments for the privilege to use process formula, or the supply of scientific information, supply of scientific equipment, and the services rendered in relation thereto, and also the list or the right to use property rights. No, so this bill will now clarify once and for all that this online services rendered by non-resident will also be subject to VAT under the withholding scheme, similar to Section 115, no? So that the withholding will be done by the VAT registered entity in the Philippines.
Yeah. Thank you for that clarification. Any, Attorney Suzette, do you have any rejoinder to that? In short, that's the intention. No. In short, that's the intention.
Okay, Mr. Chair, currently, we agree with the BIR Assistant Commissioner that currently the withholding VAT system is in place for payments to non-resident foreign entities. However, this is limited only to currently the services rendered in the Philippines by such non-resident entities, or by on payments for properties being used in the Philippines and leased out by a non-resident entity. Now, this is what we're concerned that as the BIR mentioned, that it will entirely change the the regime or the imposition of VAT, particularly on services, traditional services rendered that may be rendered, that could still be rendered even without technology. But of course, everyone wants to avail of the technology for expediency, for efficiency. So that's what we cannot reconcile, where you can render services like for a legal a lawyer, foreign lawyer, render services. What is previously not subject to VAT, rendering it an opinion sent by email or just a phone through a phone call. But now, of course, everyone doesn't use. We don't use phone landlines anymore. We just use IP phones or via Zoom, Teams, and all technology driven means of communication. So in other words, they can render it without that technology, information technology devices, or what you call that. But everyone uses it. It's already in place. So we everyone so if so in short, the fact that the foreign consultants use like a simple means like email and Zoom, that they would be covered already. And that would be, and that would go hand in hand with the income tax, maybe income tax treatment of the payments later on. Now they start on VAT, but later on maybe they will also um, like cover rendered the output sent in the Philippines, but really physically rendered abroad. Because what they are performing are the services, the legal services. It's just that it was transmitted here. It's already the output. The services are already done. It's all rendered abroad. So it's like making it's a like consumption, not the rendering of services. And in fact, they haven't amended the section 108.
Next time raw, hindi na internet. Baka by mail na lang para hindi papadala na
Yeah.
lang by PhilPost.
Balik kami sa dati na.
But right now, Attorney Suzette, I'm just kidding, no? But I mean, there's truth in that. For example, if there's a legal service outside, and then the client is here, does the client pay VAT?
The client, no, Your Honor.
Because the
Not-
service is rendered
yes,
outside.
not even withholding on income tax or VAT, because it's considered rendered outside.
But the income came from here, and the consumption came from here in the Philippines.
Yes.
So even in that scenario, they don't. I think the delivered through internet or not is incidental. What they want to capture are the services rendered outside, but the clients are here in the Philippines. I think that's what they want to capture.
Otherwise, Mr. Chair, all services that are rendered abroad, but it's a part of, well, the output is consumed in the Philippines, it will be subject everything.
Yeah, we'll take note of that. That's a good point that we need to study. But I think that is the intention. I think they want to capture that type of scenario. No, the delivery through internet, whether Zoom or email or Telegram, just incidental. I think what they want to capture is those transactions. Now, whether to put that in this bill, because the essence of this bill is digital services, no? Digital services, meaning those streaming services, digital advertising, things like that. No, that is actually the essence. No, but we'll take note of that. And in the technical working group, that's where that's where the battleground is. No, so we'll work on that. But I'm sure the DOF and BIR are also taking notes to that effect. We're also taking notes to that effect. All right. Well, Attorney Fulvio of Do Baladad Associates.
Thank you, Mr. Senator. Of course, I support the earlier comments of my President, TIMA President, Attorney Suset. Just additional comment on the earlier presentation of our friends from the DOF, PIR, and NTRC. They are actually all my friends, except that they're all my good friends, except that maybe I have the privilege to comment also. Because earlier, Mr. Chair, you were asking what really is the reason why we are going into this legislation process. Why is it that the BIR cannot impose VAT based on the current law? Why it cannot impose VAT on digital transactions based on existing law? It is because, as correctly pointed out by our friend from the DOF, Mr. Napao, in the first slide, he said that digital services where the servers are located outside the Philippines are considered rendered outside the Philippines. And the BIR had issued actually a number of rulings confirming that. That's why at the present, they are not, they cannot impose VAT because we go back to the basic principle, which is repeatedly mentioned in our tax code, that for services to be VAT, to be subject to VAT, it must be rendered in the Philippines. That's repeatedly mentioned in Section 105, 108, and other related provisions in the VAT law. That's why there's no VAT. They cannot impose. So I think the real issue, or the thing that we have to hurdle, is how to put those services, those digital services, within the definition of services rendered in the Philippines. Should we make it as exemption, or we still follow the traditional definition of rendered in the Philippines and then make that as an exemption, or we just include them within the definition of that to be able to be covered? So I think that's the issue moving forward, because the way I see it in the even in the proposed bill, hindi pa clear yan eh. There will still be confusion as to where really the digital service is rendered. Because if we retain that provision rendered in the Philippines and also retain our definition of where the digital service is rendered is, or our rules on that, then it will never be covered. Second, I think there's was also a question on the registration that would automatically make them subject to VAT. I think that's not also correct. I think the registration is for purposes is in the implementation of the collection or payment process, but it doesn't make someone liable to VAT simply because it is registered here as a taxpayer in the country. In fact, even for currently, even for domestic corporations who are really registered here as taxpayers, they are not subject to VAT, because again, we go back to the basic principle that they are only subject to VAT for services rendered here. And that supports, again, the explanation also of Attorney Suset, that if the consultant is really rendering the service outside the Philippines, then within the current definition of that phrase rendered in the Philippines, that should not be covered. Perhaps as I was discussing with my colleague here, Attorney Peralta, maybe because there are three parties involved in that: the email or the internet provider, the consultant, and the Philippine customer. Maybe the service of that email provider or the internet provider, that's the digital service itself. And whoever pays that, I think that's a digital service which is subject to it. But the other party involved in the transaction, who is the consultant, the provider, harap mo nga sa Zoom eh. Sasabihin mo ba, he is doing the service digitally? Eh, kaharap mo eh. Face-to-face kayo parang na magkaharap. But I agree, the other party there is the website, the internet, the Zoom. That is the service provider. That's the one that is subject to VAT. So I think to put clarity on all of these things, the present definition as presented in the proposed bill is not sufficient. Maybe as we discussed in the technical working group, we had to make further clarification. Thank you very much, Mr. Senator.
Thank you. Thank you, Attorney Fulvio. Tanong ko kung si Zoom kung nagbabayad, parang di yata si Zoom nagbabayad. Gamit tayo ng gamit ng Zoom. Walang VAT yung subscription namin. I think that will be captured, no, Yusek? I mean, again, kidding aside, but just to use it as an example, like here in the Senate, we use WebEx. But I doubt it if we're paying VAT on WebEx. Ako, I don't pay VAT on my Zoom subscription, no? So, but after this law, that will be captured, no?
Yes, Mr. Chair, I think the intention is to capture, but there's provision on exemptions with respect to for use by educational institutions and for learning webinars and similar activities, Mr. Chair.
Thank you for that clarification. Call on Attorney Malu of PwC.
Yeah. Good afternoon, Mr. Chair. Similar to my colleagues, no, we do not have really objection on the proposal insofar as imposing VAT on digital services. But what needs to be looked into is really on and evaluate the provisions, especially on the coverage. It's quite, well, at least for the physical goods, it was clarified earlier that it's not the one being contemplated. But it's unfortunate that on the service side, the traditional services are being contemplated to be included. As mentioned by Attorney Zuset, these are traditional services rendered outside physically, but it is the mode of delivery that is done through the internet. And if I can just on page 4 of the bill, there's that term digital service, and it refers to service that is delivered or subscribed over the internet or other electronic network and which cannot be obtained without the use of information technology. So I think there needs to be a distinction because, like, for example, for services, actually you can obtain that without the information technology. It's just that, of course, we're in the modern world and we do not use anymore. We don't want to go back to the Jurassic, you send it by fax, fax, etc. No, but the service per se, perhaps this is not really what what we're trying to capture, because like it's different from that. Those services are different from like the streaming services, because the streaming services, they cannot provide the service without the use of you cannot obtain the service without technology, without information technology. And so perhaps we're expanding our definition or the coverage of digital services. Maybe we could also look into what our other neighbors are doing, because the way I understand it, like for example, for Japan, there are certain exceptions, and this traditional services, I think, it's one of them. So probably we can revisit what really the intention is. Otherwise, we are changing the basis of VAT from where the services are rendered to a consumption base. So everything, regardless of where you render it, as long as it's consumed in the Philippines, then that's already subject to VAT. Because if that is the intention, we're changing the basic premise of how do you tax or how do you impose VAT on a service. Now, it's just that now it's digital. Also, sir, in terms of, because it was clarified early on by Yusek Daki that the digital or goods are not covered. So perhaps just for clarity in terms of the definition, because although the section 105 says that it includes those that are digital or electronic in nature, including those rendered electronically, but then in page 3, when we said for this purpose the term digital service provider, in the enumeration, we just want to have that clarity. When we say here of seller of goods, we're talking about digital goods and services. So perhaps there is a need to make some revisions on the on the proposal. Also, like for example, in page 4, the host of online auctions conducted through the internet where the seller sells the product or service to the person who offers the highest price for it. So what are we taxing here? Because in terms of the online auction, when the product is sold, the product, if it's delivered, if it's from abroad, it's imported, and therefore it's already subjected to VAT on importation. Maybe just some clarity on what do we really mean by it. Also so basically what we're probably requesting is really precise definition, if possible, of the scope of the term digital goods and digital services. So if needs to exclude really the physical activities consisting of services that are performed outside, but the mode of delivery is just via the internet. Or at least consider enumerating specific exclusions on transactions that are outside the scope of VAT. I think we also noted that there is as part of the coverage, there is the online newspaper and journal subscription from is being included. But right now, under Section 1091R, that newspaper, the sale, importation, publication, newspaper, magazines, etc., these are VAT-exempt transactions. Perhaps we can revisit that particular exclusion, no? And also on the online services, I think there is this one is on what is contemplated in the subscription-based services rendered to an educational institutions, because here in the bill it's VAT exempt. So what do we want to include in that particular provision? Is it just limited to educational, subscription-based educational services, just so to narrow the interpretation? Otherwise, if I'm educational institution, because it just says subscription-based services, so even for Netflix, I can have that as a VAT exempt. Just for clarity, if that is not the intention. And also on the, perhaps really on the rationale on the, because there is that provision on issuing BIR registered electronic ORs and invoices. No, although it seems that it is the term used is may, but maybe we want really to understand what would be the rationale of requiring, because if, for example, at least Yusek Napao mentioned that perhaps we can make that distinction between B2B and B2C. We know that for Japan that there is that distinction. It's only for B2C wherein they register the coverage of reporting it and paying directly. The VAT is for B2C transactions, but for B2B to maintain that VAT withholding. But in that case, if you maintain that VAT withholding, then you don't really need to require to register the invoice or OR, because that would already be covered by the withholding VAT, and for purposes of input for B2B, so they can already use that remittance, no, as support for their input tax credit. Because currently for B2C, obviously that's not really captured because the B2C is they're not withholding agents. And perhaps lastly, just on the registration part, also a clarification on how do we facilitate the process, etc. And there is also the provision on appointing a representative office or agent. So what do we mean by representative office? Is it really the technical definition of representative office, or we just want to have the non-resident to have an agent to report that on your behalf, the transaction. So perhaps we can drop the representative office. Thank you, Your Honor.
Thank you, Attorney Malu. Well, earlier the DOF and the BIR are amenable to make the distinction between B2B to B2C. I think that makes it a lot easier, no, for many things, including the invoice. I read the OECD toolkit, and apparently for B2C they don't issue invoice anymore, no, for obvious reasons, no. For B2B, because it's registered, you don't also need to issue invoice, no. So I think that's one amendment that we can do in the technical working group. But I want to ask the BAR and the DOF about that, no? Because here it's not mandatory, no, it's may. What is being contemplated in the invoice portion, Yusek? Do you see it necessary? If we make the distinction, do you still think that is a necessary feature of the bill?
Mr. Chair, I think the reason why we put the word may there, plus the the phrase subject to the rules and regulations to be prescribed by the Secretary of Finance upon recommendation of the Commissioner, that I think will jive with the intention of the bill to just loosely implement the receipting requirement for these particular transactions. Uh, if we require the taxpayers or the non-residents to comply with our codal receipts requirements, then it will be, I think, burdensome on their part to change their existing systems, and that will entail cost and will take time to put up to comply. So based on earlier discussions with the DSPs, they are amenable to uh, be part of this initiative, but with less burden in terms of registration, in terms of the reporting, as well as in the compliance with the receipting mechanism, Mr. Chair.
Do you see any complication if we just remove it? Although admittedly, most of the platform, probably all, no, they send some form of receipt or message electronically, no. I think some of them are in the form of an electronic receipt or electronic invoice. All of this is done electronically, but for purposes of simplicity, no, in terms of process, when we remove this, do you think will it give rise to complications?
The receipts is also the purpose of of requiring receipts may also provide us with well, tracking or tracing the transaction, Mr. Chair, as and there are probably entities or companies that would need the receipts, even if it's not compliant with the existing rules that we have, just to establish proof of purchase, or so there may be other purposes of requiring the receipts. And so if we can just put it here, then the, that may be may serve other benefits.
Thank you, Yusek. Yeah, Attorney Malu, go ahead.
If I may, just to clarify, I'm not really asking that, they should not issue receipt or invoice. No, it's really more of the BIR requiring them to issue BIR registered invoice and official receipt, because these companies, they really have their invoices and official receipt. I think the concern would be that you still require them to issue BIR registered invoice or receipt. Although currently, I think looking into the other provisions, because under the House bill, it says that if the non-resident does not register, so it's the customer that will do the withholding VAT. So I was thinking that if, for example, they register and you don't make that distinction for B2B and B2C, so the recipient or the customer would require an invoice, no, BIR registered invoice, so that they can claim input tax. But if we do the withholding, so siguro lang yung maybe we can check that ano pa yung magiging really use, no, if we still have a BIR registered OR official or invoice.
Thank you for that. That's one of the things that we'll study at USEC. I know in the OECD toolkit they did away with this invoice, part of their best practices. No, so I'm inclined towards that. No, the more the simpler the simpler for the taxpayer, the better. No, I think the compliance will be better. But we'll study this also, and we'll seek the help of DOF to analyze this provision. The other one, Attorney Malu, you mentioned about about the consumption, no, versus services rendered. Attorney Fulvio also mentioned that earlier. My understanding of the bill is really changing the way VAT will be imposed, no? Meaning it will be imposed on consumption, no? And BIR can join in later on. But that's my understanding of the thrust of the bill. And for obvious reasons, because these digital entities are all located, we don't know where, no? But definitely outside of the Philippines. And I think it will become that way in the digital economy, where location doesn't matter anymore. No? The digital economy is borderless. No? So we're changing that dimension, because even though they're not located in the Philippines, but they attract customers in the Philippines. The services are consumed here in the Philippines, and that's the change in dimension that government wants to undertake later on. No? So I think that's how, and in my readings also with other countries, that's how they are also changing to adapt to the digital economy. No? So, of course, I agree with you that we need to, that change in dimension needs to be sharpened in the bill. And I know also, but when I read the bill, I was also confused with services and goods. So we'll do the sharpening and the clarification during the technical working group. But bear in mind that that's the dimension that government wants to take, no? A consumption, I guess, a consumption principle, no? In terms of VAT, no? Yeah, go ahead, Assistant.
Yeah, actually, Your Honor, the consumption principle is aligned and consistent with the destination principle of VAT system, which the Philippines is also using. No, that we cannot, that the VAT is imposed on where the goods and services are consumed. Destination principle, Your Honor, that's consistent.
Thank you. Attorney Malu, go ahead.
So all the more that it's important to really have that specific definition, because if it's being broadened, like there should be like specific exceptions, no, in so far as what really would be covered by the digital service, the meaning of digital service. Sir, just one because it was pointed out to me in so far as the payment is concerned, because it's possible even for B2B that you do the payment via credit card. So it's via credit card. I think that's why we need to look into it more, no, in terms of how to implement, because if it's via credit card, so maybe it's not possible to do the withholding. But we'll see also on how we can help, no, in evaluating on the process and the mode of payment.
Thank you. We're joined by,
Just a
Uh,
clarification, Mr. Senator.
yeah, go ahead.
On the statement that we are changing to the consumption principle, are we applying that to all services, or we are just limiting it to the digital services? Because there's a difference if we apply it to all types of services and we apply only to digital services. Just a clarification, Mr.
Yeah,
Senator.
well, attorney, for this, at least for this particular topic, no, the digital service, no, we're applying to this, no. We haven't consulted with BIR and DOF on the general principles of that, no, but at least for this, and because of through my readings also, apparently that's also being applied in other jurisdictions, no? So, but we'll confer with the DOF and BIR on that principle, whether that will be a sweeping reform or, but as far as I'm concerned, because this bill is on hand right now, it's only applicable to this bill for now. No? Yeah. All right.
So
Uh,
sir, request lang talaga in terms of crafting that definition of digital service, because otherwise, it made me just be a sweeping, all-inclusive type of service. Thank you.
Thank you, Attorney Malu. We're also joined by some internet platforms. So later on, they can share with us their experiences outside of the Philippines. Most of the platforms that we invited are multinational, though, so they're present abroad. We'll call on Miss Peralta of KPMG. Any comments?
Yeah. Good afternoon, sir. Good afternoon, everyone. I echo what my colleagues have said about the proposed bill. Um, I think the question right now is for all of us to understand exactly the business model that is suitably taxed under digital services tax. No? And we have to bear in mind also, I think, though, that there are these transactions will really involve at least three parties, where you have the buyer, the seller, and the one that provides the online platform. And I think we have to be clear po on which entity we are taxing, because I think that's where the confusion arises. We need to understand the parties involved in a digital service transaction and see which entity is the one that should be taxed, no? Uh, and that will make it, and I think the law has to be clear on that, so that um, when the revenue regulations are crafted, there will be no issues on how to operationalize. Um, on another point po, it has been an issue. Been hearing about questions about whether this will really still protect the non-residents from being perceived as having created a permanent establishment, or we also have that concept of doing business in the Philippines. I know that the purpose right now is to concentrate on VAT, and maybe there should be clarity as well on that point in the bill, so that there will be again less questions when regulations are being crafted, and operationalization will be easier. No, there will be focus only on the VAT. Um, I think the issue on doing business or having created permanent establishment arises from the fact that in connection with registration, the non-resident digital service provider is required to have a representative office or an agent. So the question is, what will be the obligation or the role of that representative office or that agent? Yan. So yun lang po. Thank you.
Thank you. We'll call on Attorney Tristan Lopez of Deloitte, Philippines.
Thank you, Mr. Chair. I would also like to adapt all the comments of my colleagues here from TMAP and Attorney Malu and from KPMG. And also I would like just to, since we are on the matter of the basics of the value-added tax. So as the name would suggest, value-added tax, the beauty of the value-added tax is that you are being allowed to claim input VAT, so that those who are under the regime, under the value-added tax system, they will only pay the tax on the value added. So because you are able to claim input. So that's the beauty, that's the benefit of being able to register under the VAT system. So I would just like to comment on the Section 5 of of the Senate bill, that on amendment on Section 110 on claiming input VAT. No, because Section 110 states that those who are VAT registered only those who are VAT registered may claim input VAT credit. So on page 8, on line 9, there is the amendment: notwithstanding the foregoing, no creditable input tax shall be claimed by non-resident digital service provider. So considering that non-resident digital service providers, no, they are also required to register under the VAT system. So this statement is not would be considered contrary to the spirit, no, of the value added tax, that is those who are registered under the regime may claim their input VAT credit. So it's just me, probably it's just me nitpicking on this, but it's no longer the VAT that is being paid by a non-resident digital service provider is no longer value added tax, rather it's just mere sales tax and not value-added tax. That's all, Your Honor.
Thank you. Seems like yung mga accounting firms, pare-pareho yung kanilang comments. So we'll go on to the platforms. I'll start off with Google, with Yves Gonzalez, who was our ano ka ba before, manager sa MMDA.
Traffic Director, Mr. Chairman.
When I was in MMDA before.
Traffic Director.
Traffic Director. When I was a mayor, siya po yung aming traffic director sa MMDA. Si Yves invented that, just a little trivia, he invented the traffic app.
The MMDA Traffic Navigator.
Oh,
Mr.
Traffic
Chairman.
Navigator, not
A digital service.
yeah, that was the first app yata, no? Na digital service na VAT-free. No? But we all used that before when I was a mayor, because we all know the traffic here is horrendous, and one of the earliest form of traffic management through an app was invented by Yves during our time in MMDA. So had a good experience with Yves during our MMDA days. But it's good to see that you're now with Google. And any comments on the bill?
Thank you, Mr. Chairman. Good afternoon. Thank you for inviting us here today. We at Google have been engaged on this proposed legislation since the start of the pandemic in 2020. And we are overall aligned with the objectives of the bill and only have some minor but crucial recommendations which we have submitted in our position paper. For example, we are recommending provisions to allow group registration or single registration for a group of companies like Google. We're also recommending better wording on the requirement to designate a representative office, as mentioned, to avoid unintended consequences with the current wording of the provision. We're also recommending improvements on the provision on invoicing, as mentioned, definition of digital services, as well as in the transitory provisions. So we look forward to sharing our inputs and best practices in the ASEAN region at the TWG. Thank you, Mr. Chair.
Yves, the Google is present here in the Philippines.
There is
You have an office
Google.
here.
There is a Google Philippines office in the Philippines.
And the office is it a support office, or is it an office that does business here in the Philippines?
The Google,
or both?
It is primarily support and marketing entity.
And then you solicit business here in the Philippines.
We provide support services to the other Google group of companies.
But not, for example, if I know Google has like Google advertising, you can individuals or companies can go to Google and um, uh, contract with Google in terms of advertising. Is that is Google soliciting that business here in the Philippines?
So the digital service, let's say the ads, for example, is still owned, operated, and run by Google LLC in the United States, and so it is not owned or operated by the Philippine entity.
That's what I wanted to find out. So, um, because I was going to ask the representative office, since you already have an office here, how will this law affect that relationship, or will it still stay separate between that business and also your support office here? How will
So
it work?
we'll have to thresh it out, I guess, during the implementing rules and regulations drafting. It perhaps we don't know if the rules will require us to will allow us to designate a current local entity, or we could designate one of the accounting offices that we engage in the Philippines to be our representative.
Thank you for that. We're also joined by Lazada, represented by Mr. Jostin Campania.
Yes, Your Honor. Good afternoon, Mr. Chairman. First and foremost, thank you very much for inviting Lazada as a speaker here in the value-added tax meeting on value-added tax on digital transactions. Lazada supports the efforts of the different branches of government to continue the evolution of the Philippine tax system so that the system is able to anticipate and adapt to the ever-changing commercial environment. Lazada acknowledges that many concepts were introduced before the rapid rise of e-commerce, the widespread adoption of app-based or web-based commercial platforms, or the massive consumption of digital goods and services. We recognize that the current proposed bills keeps intact the taxes imposed on and the tax procedures to be followed by domestic corporations who operate electronic commerce platforms. We note that the proposed bills applies the VAT regime to foreign corporations which do not have any registered presence in the country. Being a domestic corporation registered here in the Philippines, Lazada eServices Philippines Inc. is not directly affected by the enactment of this law. However, we do note that similar to other businesses and consumers in the Philippines, Lazada purchases digital services from non-resident corporations. Thus, any VAT collection requirement imposed on non-resident service providers would ultimately be passed on to the buyers of goods and services in the Philippines and may lead to higher prices and increase the cost of doing business. We intend to submit our position paper to further evaluate, to further thresh out and expound on the possible impacts of this bill. Again, thank you very much for the opportunity.
You'll be a prime example of a B2B customer
Yes.
under this bill. No, you're a prime example for that. And right now, I would assume that a lot of your digital services are located outside of the Philippines. And right now, there's no VAT imposition on those digital services that are outside of the Philippines.
As I understand, yes, Your Honor, there are no VAT input.
Because there's no law, no?
Yeah, for those services that we avail of from non-resident
Can you
providers.
just give us, because you mentioned earlier that it might impact prices of goods, no? I just want to understand, just give us a flavor, maybe not in detail, no, because this is probably proprietary, but what are those services? Because I know that Lazada and Shopee they sell goods, no? But in order for the platform to operate, you have to have servers, you have to have other services, and those can be contracted here or abroad, no? But those are for the platform itself. But I just want to get an idea, what are those services that will be imposed VAT later on when the law, when this proposal becomes a law? Well, just give us an idea on those type of services.
Thank you very much, Mr. Chairman. For instance, for purposes of discussion, Mr. Chairman, for instance, cloud services, where we store data, or perhaps cloud computing services that are performed outside of the Philippines. Office suites like Microsoft and all that, as an example. If these services increase in so far as their costs are concerned, necessarily will have to adjust as well in so far as our operating expenses are concerned.
All right, thank you for that. We'll call on Amazon, represented by Ms. Christine Tamayo.
Good afternoon, Mr. Chair. Thank you for the opportunity. Actually, Mr. Chair, we're from Casabing Torres, representing the Digital Economy Group, including Amazon. It's a local coalition of multinational companies engaged in commerce, both digital and non-digital. Mr. Chair, the members of the DEG, of the Digital Economy Group, supports the passage of this bill imposing, or that seeks to implement the extraterritorial VAT regime, as what most of us want is just to help in making sure that the government comes up with a law that is more or less consistent with the global best practices, so that the law would not have unintended tax implications that can cause problems, a lot of problems later on. And this is something that we have also espoused in the position papers that we have submitted to the Senate and even to the House of Representatives. And we would like to underscore from a business perspective that one of the more important features of an extraterritorial VAT regime is consistency, to make sure that the rules are consistently applied by these non-resident enterprises in most jurisdictions across the region or globally, because the consistency would allow these non-resident enterprises to actually comply with the requirements with the fewest modifications in their systems. Because if we, for example, depart or deviate from what is being done in other jurisdictions, then we might even hamper the compliance with what we intend to implement here in the Philippines. Having said that, Mr. Chair, we espouse and we are happy that the Department of Finance, as already noted by Yusek Napao, actually already supports the best practices, the global best practices, and even discussed by the other members of the private sector. For one, Mr. Chair, we hope to exclude the requirement to actually set up or establish a representative office. If or when we include that requirement to establish a representative office, then we believe that it is imperative that the law is clear that it will not establish a direct tax nexus, because we are really just focusing on the implementation of an extraterritorial VAT regime. Number two, the simplified registration system, which was also noted by Yusek Napao and other members of the private sector, to make sure that it's simplified enough, consistent with what is being done in other jurisdictions, and to adopt a pay-only basis. Again, the goal of this recommendation is to make sure that we don't require non-residents to comply with very complicated requirements that would even deter or be counterproductive to what we intend to implement. Number three, again, as what we have repeatedly mentioned, the application, the coverage of the bill to just cover B2C transactions and not B2B transactions. And this is something that I think has not been mentioned yet, the reliance of the non-resident to what the best practices call the proxy categories, meaning the non-resident should be allowed to rely on evidence that is presented by the customer to show residence and to show that the customer is either a business or a consumer without further inquiry. And lastly, and I think this was also noted earlier, the non-requirement to issue BIR registered invoices and receipts, and to just allow the non-resident enterprises to use their own invoices and receipts for purposes of the transactions here in the Philippines. That's all, Mr. Chair. Thank you.
Thank you. Thank you, Ms. Tamayo. You mentioned consistency, can you give us some of those items that you want to be consistent with global best practices? And maybe you can also elaborate some of the things in the proposal that you see that are not consistent with global best practices. So we can capture that on record and we can rectify that later on in the technical working group.
Yes, Mr. Chair. Number one, Mr. Chair, the B2B, I think the bill as it's currently drafted, the language of the bill appears to include even B2B transactions. So that's one, Mr. Chair. The scope of the regime to just be limited to B2C transactions. Number two is a non-resident enterprise is presumed to be, should be entitled to presume that the supply is B2B if, for example, the customer presents VAT registration, because a consumer would normally not have any VAT registration here in the Philippines. Number three, as noted earlier, Mr. Chair, reliance of the non-resident to evidence presented by the customer to show residence, for example, government issued IDs or the IP address of the customer without further inquiry. Number four is the simplified registration system, as already noted by Yusek Napao. Number five is, again, the invoicing, Mr. Chair, again, not to require non-residents to comply with the invoicing requirements under the tax code, securing authority to print or issuing BIR registered invoices. Those are some of the best practices that we are espousing, Mr. Chair. And will be happy, Mr. Chair. We actually have submitted a list of the best practices that we are hoping for the TWG, for the Senate to consider, and we are happy to resubmit our position paper with a list of best practices, Mr. Chair.
For assuming we take the distinction on the B2B, B2C, and it seems to me that that's a best practice being implemented in other jurisdictions. How, from a customer point of view, for example, I think B2C is easy. You just register. Let's say Netflix, you just register, or you just sign up. For B2B, how do you make that distinction? What do you, from a platform point of view, what type of requirements will you require to know that the customer is a B2C or a B2B?
Mr. Chair, for one, the customer or the consumer here in the Philippines can present its registration with the Philippine tax authorities, with the Bureau of Internal Revenue, that would show that it is actually a business. It's an entity conducting business here in the Philippines, procuring digital services from the non-resident enterprise, Mr. Chair.
Now require that, for example.
Yes, Mr. Chair.
Ano lang, loosely. So if I'm a business, I will be required to submit other documentary evidence to prove that I'm a business.
Yes, Mr. Chair. And one of the best practices across the region, Mr. Chair, is for the non-resident supplier to be allowed to just rely on these documents being provided by the customer, and not to make further inquiry, because it will be too cumbersome to make further inquiry into the real registration of the customer. So long as, of course, the evidence presented by the customer is reasonable, it provides reasonable evidence as to the nature of its business, if it's a B2B customer.
For of course, the Amazons and the Googles of this world, it's easy. But for small and medium digital service providers, I think, like for example, Amazon, Google, you probably have the tax rules of every country in the world, no? But for small, medium digital service providers, they won't have that information, no? So, and then let alone issue an official invoice, no? So that's why the invoice thing, as what Attorney Malum pointed out, should be evaluated, because we're not only looking at the big digital service providers, we're also looking at the small ones, the medium ones. I think registering for them is already quite cumbersome, no? So, and most of these medium-sized, small-sized digital service providers are some of them are family-owned, some of them are just run by a few employees. So, but then again, they provide service, and there are customers who value on and engage their services. No, so that's why my track is to make it as simple, as easy as possible, not only for the big companies, but also, most especially for the small companies. No, so
Yes, Mr. Chair. I think, Mr. Chair, and I think maybe the DOF or the BAR can chime in. I think that's where the deemed supplier approach comes in, where I think part of the definition of the DSP or digital service provider is the platform where these transactions sometimes happen. But then again, we also, we also have some exceptions to that, the implementation of the deemed supplier rule, to make sure that if or when that is implemented, where, for example, the platform is required to be the entity assessing, collecting, and remitting the VAT for the transactions that go through it, then certain parameters should be followed. I mean, for example, if you are a platform that is just what we call a bystander, and you are not really a deemed supplier based on the deemed supplier rules as it is understood in other jurisdictions, then you should not have that obligation. But I think that's if I'm not mistaken, that's one of the purpose of implementing that rule, with, of course, again, Mr. Chair, certain exceptions.
thank you for that. And lastly, we have Shopee. And full disclosure, I'm a platinum member of Shopee. I buy so much from you guys, but below 10,000, so I don't pay the VAT. No, so let me call on Attorney Jem Segovia of Shopee.
Thank you, Mr. Chair, and it's very good to hear that you are a platinum member of our platform. So thank you, Mr. Chair, and the Ways and Means Committee for inviting us here. It is our honor and pleasure to be here physically, because we've gotten used to having our hearings virtually using these non-resident digital service providers. Anyway, by way of introduction, Shopee is an online platform that empowers both buyers and sellers to transact online by providing them with a space. We would also like to share that Shopee is a locally incorporated corporation and is therefore subject to local taxes like income tax and VAT. Rest assured, Mr. Chair, that we are committed to supporting the government's efforts towards economic growth while also maintaining a policy environment that enables the growth of businesses in the digital space, especially small businesses. We have actually submitted our position paper on this bill. A lot of our points have been sufficiently covered by our colleagues from the private sector. Nevertheless, we would be happy to participate in discussions of this bill moving forward. Thank you, Mr. Chair.
Thank you for that. I guess it's the same, no? That most of your, I guess it's the same with Lazada, no? That directly you're not cover. I mean, the goods that you offer to your customers are not covered by this bill, but the services that you contract, no, will be covered by this bill. And I guess it's the same. It has the same effect to your customers. Is that an accurate statement?
Yes, Mr. Chair. In fact, our comments are basically from the point of view of a Filipino purchaser of services provided by non-resident digital service providers.
I don't know if you can share that with us, but how much of an impact will this happen? Because I would just, I'm sure Lazada and Shopee has millions of customers, and I would assume that the incremental impact of this bill will be spread all over your customers and your products. So if it's possible lang, I just want to cover that base, the impact to consumers since you opened it up. But if you can share that with us, maybe on a broad stroke lang, if not accurate, on how can it, what impact will it have to products and to the items that you offer your customers for both Shopee and Lazada. Later on, not just you can just submit it to us. I know you have to run the numbers, so you can just submit it to us. No, all right. I'll covered all the private sector, but I'll go back to the DOF and BIR on some items. No, in the bill, there's a earmarking of 5% to the creative industries. No, any particular? What's the particular reason? But maybe you can answer that. What's the particular reason for earmarking 5% to the Creative Industry Development Fund? No, in fact, I don't even know that we have this fund. But is there any? I'm sure it's for the creative industry, but is there any particular direction why we are allocating it to the Creative Industry Development Fund? And is the DOF pursuing this? I know the DOF doesn't is not so inclined in earmarking. No, it's better to go everything to the treasury, and we give government the flexibility to allocate the amount. Especially this amount is no small change. It's about 17 billion. No, so although 5% is not that substantial, but it's a principle that I'm more looking into. First is any reason for that earmarking, and what's the direction? And then second, is the DOF still pursuing this earmarking?
Mr. Chair, from what I understand in the discussion during the House deliberations, the creative industries, they supported the passage of this bill in the House, and they were able to have this provision inserted. But I think the probably the reason why there's earmarking here is that we're talking about streaming live music like that. So they're saying that this will affect them, and that they will contribute. So I think that that's the basis, because they're expecting that we will now be capturing the downloads, the streaming of music, art designs, etc., electronic art.
Okay, so in other words, because we're going to legitimize, well, maybe legitimize is not the right word, but we're going to attract streaming services to come into the system. We'll take advantage of that system by helping our local creative industries compete and develop.
Yes,
I think
yes,
that's the logic.
I think there's the reason for the earmarking is something to that effect.
Is DOF supporting that, or you have to think about it, or do you want to support that?
We submitted our position paper, but I think there will be another round of Mr. Chair, we'll try to look into it, but
Yeah,
as of
okay.
now, we have no opposition to this.
Okay, all right. And then I heard from Ms. Tamayo about the representative office, and I heard that from a resource person. What do you envision for this representative office to do here in the Philippines? No, and I've talked to some of the non-resident digital service providers, and they seem to be quite uneasy with that, no, because obviously it's added cost, it's added administrative or added operational activities for them. So what does DOF envision for this office to do, no, in behalf of the platform and also for government?
Yeah, we do confirm that part of the so-called best practices is that, and I think this has been practiced in other jurisdictions, is just to avoid the fact of establishing a PE that will trigger other taxes like income tax on this income stream or of these non-resident digital service providers. The Congress, Ways and Means, they put the requirement to either assign an agent or an office just for the purpose of complying with the provisions of the, like say, filing, etc. Although we are also envisioning the filing here via the ORO system. In fact, it's underway. The VAT payment portal is will be once the bill will be passed, it will already be constructed, Mr. Chair. So, but there's already an existing system that will cater to the registration of all these non-residents for VAT purposes. It's already in place. But once this is passed, the payment portal will be constructed right away.
Because I mentioned before, we're also looking at the small and medium digital service providers. No? Not like, for example, there are small streaming service, very, very niche streaming service that caters to a niche customer base. So I think it will be quite difficult for them, no, to designate, appoint a representative office here, considering that they're not big, no, they're not present all over the world, and we might not capture them, or we might deter them from going into the system. No? So that's one of the things that came to me, when I was looking at this provision. No? So yeah.
Mr. Chair, although I think this also mentioned about an agent, which can be a person that can be appointed as someone who can act on behalf of these non-residents if they are just medium term or medium or small enterprises.
The agent will still cost, no? There be
Yes, perhaps, but
some
it
cost
will
for
be
them.
minimal compared to an office established, Mr. Chair.
Yeah, let's study this carefully, because I also note that in the OECD toolkit, this is not something they advise. No? Although I think some jurisdictions do it, but if we can do away with it, and if there's a way to do it everything digitally, no, and that is the essence of this bill, then let's do that, no, instead of coming up with a physical office. And then on the audit side, USEC and Assistant Commissioner, how do you envision to audit, no, declarations? Um, how do you envision to do that? Obviously, all of this, they're non-resident, they're not here. No? Do we just fully trust the disclosures of the DSPs? How do you envision to conduct audits? How do you envision to go to validate the documents that they submit?
It will depend, Your Honor, on the compliance registration that will be crafted by the BIR and the DOF on how they will be reporting to BIR on the transaction. If it is just a simple transaction, simple reporting, or there are other matters there, so it will depend on that information. Also, we can avail of the facility of exchange of information with other treaty partners to verify the transactions. So we will be utilizing that, Your Honor.
Can I ask the platforms if you have any experience with other jurisdiction insofar as audits are concerned? How do you report? Obviously, you report, no? You remit, you report. But is there a process on how the tax authorities conduct their audits, or what type of reports do they require? Anyone from the platforms, if you have any experience in that, no?
Unfortunately, Mr. Chair, we don't have information on that at the moment.
Yeah. Wala. All right. We'll request nilang from the BIR, no, on how do you plan to conduct validation and audits, because obviously they will just remit, they will give you a report. But in a traditional brick and mortar business, you request for books, the books of accounts, access to records. But ito, walang access to records eh. There's no access to records whatsoever, no? So and I know part of your part of governance is to make sure that the reports that we are getting is accurate and validated, no? We cannot just take it everything hook, line, and sinker, no? So I want to, it's not in the bill, but just think about that and submit to us a position paper on that topic. I've called everyone, no? Unless any comments from the body, any suggestions, comments, any more insights from the things that you've heard heard from our resource persons? If not, naman, based on the comments and the what's this? Yeah. When do we do the TWG? Wednesday, pwede? Huh? When's Wednesday? Dali, Yeah, well, based on the feedback and the comments that I've heard from our esteemed panel and resource persons, I think there's no violent reaction naman to this bill. I think Attorney Malu and the team made very clear comments on what to clarify, and we will do that as we go along during the technical working group. So we'll go now to the next step, which is the technical working group, and this is where all the fun part will start, no? Because we will talk about the provisions, and we go line by line so that we sharpen all the provisions that we need to clarify. So tentatively, the TWG will be on Wednesday, which is July 12, 10 a.m. No? So tentatively, but we'll issue a formal invitation to all so that you can join us in the technical working group. So just a few more items to submit for DICT, which is very important. No? The process of blocking websites. No? I think this is a very important feature of this bill. Unless pupunta ho kayo sa Amerika, doon nyo i-close ang mga websites. No? So, but submit to us a position paper on this. No? And of course, to Shopee and Lazada, if possible, extend of the effect to your products. We just want to get a flavor of what is the downstream impact to our products. To DOF, a discussion on the earmarking of the 5% revenue. And then to the BIR on how to audit the reports that will be submitted. So please submit these items to us or before the technical working group, which is July 12th. All right. So with that, we'll again thank you very much for your time and candor, and of course your inputs. I thank you very much, for giving us your insights on this proposed measure. So with that, this hearing is hereby adjourned. Thank you. Thank you very much.